What are you trying to hold down there, Suzanne?
Oh, my lovely locks.
Is it windy in there already?
Yeah, I forgot about all the thousands of people that watch these live streams.
Okay,
Yes.
so before we start talking substantively, I think I need to read the conflict statement, even though it's a subcommittee meeting. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest in the appearance of conflict, and are instructed to refrain from participating in any matter coming before the subcommittee with respect to which there's a conflict of interest or appearance of conflict. And everybody knows that drill. So assuming none, and we have Ms. Brocker, who started it all, joining us now. So everybody has received from, I think Brian, maybe Suzanne, I can't remember, the two options, sort of, we'll call it the 8-paragraph prospective client analysis and the 4-paragraph prejudicial to the administration of justice analysis, and that should be one hint. But because I have people here and I've already been privy to some discussion with Brian and Suzanne directly that the rest of you have not, I'm going to mute and turn it over to them to walk us through how we've sort of done a deal. So take it away.
Go ahead, Brian.
Okay. It's like, who's going to do this one? All right, so yeah, Suzanne and I, we've been going back and forth on this thing, and I think the way that our overall just discussion in the subcommittee has gone, there's been kind of a bit of unease with going the prospective client route and just trying to figure out what is the best solution here. So, we following the last subcommittee meeting, I think we were still on the prospective client determination. But there were some concerns about the potential ripple effect of labeling folks that contact lawyers through these types of ads as prospective clients. There's confidentiality concerns, there's potential conflicting out concerns, although the opinion is saying ultimately that lawyer cannot do this, cannot participate in this because of the inability to keep things confidential, which if this person is a prospective client, you have a duty to keep this stuff confidential, and the structure of the program itself is problematic. It violates all those different responsibilities for confidentiality. But the thing that I think bothered, I'll say bothered me, I think it bothered us, was that it felt like there was still some sort of window open that the business structure could change. The business could alter its practices, and I think to potentially comply with our concerns or alleviate our concerns ethically. But that really didn't. That meant that the opinion wasn't really striking at the heart of the matter from what we understood the subcommittee to communicate, which was that using this type of service by which a client reaches out for legal services to a lawyer and is recorded, that conversation is retained, is potentially disclosed without their prior knowledge and consent. It just did not, I think it gave everybody some sort of dissatisfaction, did not feel like that was the appropriate thing for the protection of the public. And so that's what led us, we were kind of circling around this notion of, well, it seems like maybe it's prejudicial to the administration of justice in general. And that's what led us to kind of an alternative analysis. So the first opinion you received that's labeled in that email that was sent out to you all as Alt Opinion 1 is the one that has the prospective analysis or prospective client analysis. The second one, Alt Opinion 2, really does away with any mention, not really any mention, but does away with prospective client determination and analysis. And references that the ethics committee is hesitant, is concerned with calling these folks prospective clients, but really just that the structure inherently is prejudicial to the administration of justice because of the reasons I just mentioned, the whole recording, retention, potential disclosure of information, and even kind of regardless of any sort of warnings that are given to the client about their information, their words, their communication with their potential lawyer, even if they're told what's going to happen, it still just is not a mechanism that really ensures protection of the public and protection of those client interests. So that's the two differences. The first inquiry on both, of course, is the same. It's the second inquiry where they're different. And I guess we want to get your feedback here. If I know we've talked kind of ad nauseum about are these folks prospective clients? Is that problematic? Things of that nature. Or do you think that the prospective client analysis is accurate? Is what you think is appropriate for resolving this particular inquiry? Or do you feel more comfortable with the other alternative, which really just labels the general structure of this program as something that is prejudicial to administration of justice? And the reason being because people who are seeking legal services, they are in a way, in a pretty significant way, they're seeking justice, whatever it may be. They're seeking the resolution of whatever legal problem they're facing. And a part of that administration of justice is the kind of understood reasonable expectation of the client that the conversation they have with their lawyer will be exclusively with their lawyer, or the law firm. It will be private. It will be secure in that regard. And no matter or no amount of warning or anything really relieves the duty of the lawyer to provide an exclusive and secure mechanism by which you can communicate with your lawyer. So with that said, kind of want to just get the subcommittee's feedback on which version you prefer. Do you like either? Do you not like either? And we need to go back to the drawing board. Just where are we at?
Well, of the two, I prefer the second one where it's the administration of justice. I think that's a little squishy, but i.e. vague, but the problems with the collateral consequences of labeling somebody who calls these lawyers who do this service to call them prospective clients by the mere fact that they call the number on the screen, I think I think that would be bad. Frankly, I think it would have collateral consequences. I think it would be hard to differentiate this service from some potentially other services that are out there that invite people to call lawyers and send them emails. And I don't, where do you draw I just like, and in fact, if it was a choice between the prospective client and just the prospective client analysis for prohibiting it versus the only other choice was just to allow it, I'd prefer to allow it than to label these folks that call this number to be labeled prospective clients. I just think the consequences are that, ethical duties are imposed on these lawyers by any telephone call that is made to their office, period, if we call them prospective clients versus this other one where you kind of are, it's more of a, you better not do it just because we don't like it.
Well, I'll say that I prefer the second opinion to the first one. Everything that everyone said about potential clients, but also I didn't like the whole idea of this program at all, and period. Especially if you're looking at, people who may not have financial resources, and this is the quickest and the easiest and the cheapest thing that they can think to do. And so they're clicking on Google and they're not understanding that their information is going to be retained. What they're saying is going to be retained and how that could negatively affect them. And, I know if you have warnings and all of this stuff, but don't tell anybody, but I just click on okay a lot of the times without reading, and I can't imagine that, normal non-lawyers do that just as much as I do. So, I mean, I don't like the idea of the program period, but of the two opinions, the second one, I prefer that one.
I agree with Lauren and Takia. I prefer the second one, and I would in fact propose beefing up that last paragraph where it says, while the ethics committee is hesitant to classify a consumer using the LSA program as a prospective client, the committee is concerned that LSA structure employs a mechanism through which critically important client confidences could be made vulnerable. And I might include some examples of that to make it clear what the concern is. A couple of which we've talked about are, I know if I'm remembering correctly, Gina said that these could be subpoenaed, these phone calls could be subpoenaed by adverse parties, that there could be, in the world of the internet, inadvertent disclosures to unrelated parties. And I would use, offer at least one example just to show exactly what it is, because being made vulnerable, that doesn't, to me, say enough about why this is problematic. And so everything in the second one I completely agree with, and I would just offer to add that or something like that.
Yeah, I like that. Can we also beef that up? Beef
Beef it up.
I don't know, whatever the word is. Rather than saying we're hesitant to classify, can't we say, while a consumer using the LSA program is not a prospective client under Rule 1.18? Can we
Not necessarily a prospective client.
Not necessarily, or something like that, well, they might be if you told them to call that number in a separate yeah, I don't know.
Yeah, well, Warren, I'll just offer that's something, we I think kind of intentionally came down on that language because
Okay.
of the question. I think it's a reasonable question about whether or not this person is a prospective client. I think we're all uncomfortable classifying it because, like what you said, the potential collateral impact and consequences of that. But depending on the circumstances of these different programs, I guess I, in a way, want to signal, and I think it's an appropriate signal, that depending upon the structure of the program, it very well could be creating the consultation that the comments talk about for Rule 1.18. So I guess that's where I thought it was more appropriate just to kind of say, like, they're not going that direction. They're not where I think the ethics committee doesn't think that we're in 1.18 just yet, but it's like we're circling around. It's in this weird sort of netherworld of technology and our understanding of how consultations are created. But I think to your point, Ripley, yeah, I think that'd be good. I wanted to also mention that Lamar had sent a comment to Suzanne along the effects of kind of what you were talking about, Ripley, to mention that the disclaimer, even the reason why a disclaimer is not enough is really even because of the chilling effect that this program can have on communication, that communication is supposed to be forthright and full between lawyer and client to effectuate the best representation that possible. And knowing that you're recorded, knowing that you could have your words disclosed, could inhibit that. So I think that kind of plays into your point, Ripley, of being a little bit more specific about why this stuff it can make client confidences vulnerable, why it has a negative impact on the ultimate communication that's meant to explore representation.
So,
Go ahead.
okay. I'm on that wavelength entirely, but I was focused on Ripley's wavelength. That is, I was focused on a different
So that's a bad place to be. I
group of.
advise you
I see
against
all that
if you can
space
avoid it.
stuff in your
I know.
background, so I don't know what that
What a
says about me.
wavelength.
So I'm focused on a different sentence and some different words. So the last sentence says, accordingly, the lawyer's use of a program that is designed to fail a consumer's basic expectations of privacy and exclusivity. I think that's milquetoast. Designed to fail. It's designed to exploit or designed to compromise or something, to the point that we are not going down this road because we do not want these people to be exploited. I think that's really the bigger point. I think designed to fail is just too soft of language to make that point.
Is subvert the word? Is that a word?
Yes. Yeah, that's a great word. Something like that.
It is a word, Ripley.
I'm relieved. Thank you. I'm glad by popular vote that we've decided that's a word.
Deanna had something, I don't know.
Yeah. Oh, thanks, Suzanne. And I sort of look at this from a different perspective. And I completely agree with Ripley's comments. I do think that the specifics are important, but for me, they're important for a bit of a different reason too. When I'm looking at these ethics opinions, I'm looking at them in terms of, okay, can a lawyer down the road be disciplined for violating Rule 8.4D? And does the ethics opinion sort of expand that, or, realm of conduct that could be caught up under the Rule 8.4D umbrella? And so that concerns me. But I think that adding specifics, especially with regard to bringing it back to subpoenas and court-related type proceedings, I think will keep the definition of 8.4D from really expanding beyond where you would otherwise want it to be.
I think that's a really good point, Deanna. And that's something I guess I want to make clear in coming up with this alternative. I guess speaking from my position, my old position in the Office of Counsel, I was always hesitant to plead 8.4D unless it was really some sort of conduct that affected the administration of justice. It's almost procedural. It interfered with the ability for the court system to move forward, things of that nature. I know that perhaps in the past it's been sometimes used as a catch-all, but it's not. I think there is some meaning to it. I think if I had one concern about this opinion or this particular analysis, it was that concern. Like you said, Warren, this feels a little squishy and potentially a little vague. But I guess that's where I ultimately do feel comfortable looking at the administration of justice, not just, hey, you are standing in front of the courthouse steps preventing the judges from getting inside the building. We're looking at the scope of potential client, just consumer seeking legal advice, seeking legal services. And this, from the very outset of someone's ability to achieve justice, really is kind of, as we're talking about, subverting a client's expectations and ultimate ability to get that sort of legal representation, legal advice, legal service that they are looking for. So I ultimately am comfortable with it, although I recognize the potential expansive nature of 8.4D under this. And to that point, I totally agree. The specifics can help ring that in and describe exactly how this affects the administration of justice. So I think we'll put some of those things in there, some of those examples, and we can share that with the subcommittee. I don't think we necessarily need to have a vote today, just procedurally speaking for the subcommittee. I think we could essentially send out the new examples that we agree upon here and just kind of a final version, and the subcommittee members that are present at next week's meeting can make their recommendation about if this is ready for publication. I think just so we're clear, we don't want to get into some sort of reply all situation where everybody's emailing each other because that could be potentially violating the Open Meetings Act. If you have any sort of feedback after we send kind of the updated version, I would suggest just emailing Suzanne directly, or you can copy me on it as well. But that way we can kind of compile the thoughts and share the results.
Deanna had one other comment. I know that originally we had drafted this opinion naming Google. And then, as is our custom, we went back and we made it generic. And Deanna is concerned like that there's so many lawyers that are already participating in this program that they need to know what we're talking about specifically. So I'm just.
Yeah, thank you,
That's a
Suzanne.
good point.
My only other comment is that if there's a way to use Google as an example, not exclusive, but either in the head note or in the first paragraph or something, because I'm concerned, and this has really already changed the landscape of legal advertising from what I understand. And you know, this Google service, local service ads has really kind of sucked up all of the business. And so there are some folks who, if they were reading the head note of an opinion that was too generic, wouldn't really be put on notice that they may need to extract themselves from the program.
We could do that, right? We could use, for example, is there anything else that's like this that if we wanted to use another example?
I don't know of anything. There might be, but I don't know.
There's bound to be somebody.
There
doing
will
it.
be if there's not yet.
Right.
Yeah, I think using as an example is a good way to go. Not necessarily labeling this a statement about Google's service, because if Google changed, like we saw with super lawyers and those different types of organizations, when you name a specific organ or business company, all they have to do is change their structure, and suddenly they might come into compliance
Right.
with the ethical concerns, and suddenly we have this very negative "do not use this service" that's just causing more confusion, because maybe we want people to adjust their business practices to be more in compliance with the rules, so that would enable that to happen.
I think we also need to give notice to Google, because apparently their sales reps are telling lawyers that everything's okay in North Carolina. North Carolina is on board with this. So that's what I'm hearing from some of my clients. And yeah.
Deanna, I haven't seen this issue addressed by any other jurisdictions. Have you? Do you know?
No,
Sorry.
That's all right. I'm familiar with the Wisconsin sort of, sort of informal opinion out of Wisconsin, but I don't know of any other states that have a formal opinion on this, but I have to say I haven't looked recently.
Okay, so if I'm understanding where we are, we have a unanimous agreement that we like the administration of justice analysis better than the prospective client analysis. It sounds like we need to stay generic, but mention this Google LSA as an example of what we're talking about. We need to give some examples and use a stronger verb about why we object. Is that it?
I think so.
Good.
I need to do something about these crazy dogs in my house.
I'm trying to think. So, you know, is it equated to something like this? Would this be a good what do you call it? A disclaimer. If you had your website with your contact information, somebody clicked on your email and a little box came up and said, click here to show that you understand that this communication you're about to make does not form any sort of attorney-client relationship, yada, yada, whatever that disclaimer is that we talk about. But then we also added a sentence at the bottom that said, and you agree that I can take this message that you're about to send to me and give it to third parties and have that as a possibility to click. well, yeah, we disclaimed the prospective client, but we also just set up somebody by inviting them to give us the permission to just send it off to third parties, and we're lawyers, and that's not what we're supposed to do, right? That seems like,
Yeah, we've got to be protecting all kinds of people, mostly the people who are clueless. They're the most vulnerable to that kind of stuff. So I don't like
And we're
that.
all conditioned to click crap like that all the time
Exactly.
now without reading it. I mean,
And it-
and that's the
right.
world we live in.
and that's my point. It's one thing to say for the lawyer to be protecting themselves, to say, you understand that we're not forming an attorney-client relationship, but then another to say, and you're giving me permission to share this information you're about to send me with third parties. That doesn't seem to be a good disclaimer.
Yeah, Warren, that's exactly kind of why I think I personally floated back to 8.4D, because this is foundational in what lawyers do and what people looking for legal services expect and should expect. So I think you kind of hit the nail on the head there.
Cool.
Okay, one more point of clarification. So if I'm to understand you correctly, Brian, the next plan is for you guys to look at these 3 areas of tweaking, to tweak it, to send it out to us. And if anyone has any additional comments, just to reply, not reply all, and get that information in front of you. And then we can talk about it at the ethics meeting.
Yeah, I think so. I think we can hopefully Suzanne and I can make these tweaks and send it out to you all, and you think that's great. That's because ultimately we're trying to get to a place where we can publish this thing, right? So that's if we do our job successfully, then we'll be there. If there's something that you feel like, oh, this is missing, or I would include this as another example, then by all means, just shoot us a quick email, and then we can kind of, say, hey, we got some feedback and, wanted to include this as an additional example. Here's the final version. But we don't need to necessarily have a vote here. The vote really comes, or I should say the subcommittee's action and recommendation comes at the full meeting. So we can kind of hold off till that point. But if we get to the point, I think as far as timing is concerned, we are going to have an addendum agenda for the ethics committee meeting. It's going to go out either Friday afternoon or first thing on Monday. It's not going to be very thick. I think there's going to be a new inquiry. There's going to be hopefully this as well as some minutes for another subcommittee meeting that's going on this week. But my point is that I think Suzanne and I will try to make these tweaks, fairly quickly and send something out to you tomorrow. So if you guys can just kind of take a look and give us a sounds great, or maybe, adjust this a little bit, that'd be really helpful. And we can get this on the addendum and get it published to the entire committee.
Sounds like a plan.
Cool.
Great. All right. Well, that's all we got. Is there anything else we need to talk about, Gina?
No, sir, not to my knowledge.
You need to
All
get
right.
back to your vacation.
That's right.
Well, I don't know. It's the storm that's brewing.
Well, you need to get down to the basement then.
Right, exactly. Okay, guys, I will see you all next